And thanks for being with us. Welcome to our webinar, California Employer Considerations and Best Practices for Returning to Work in the Wake of COVID-19. I'm Jessica Hawk, and I'm Special Counsel in Litigation and Labor and Employment in Buchalter's San Diego office. And with me is my colleague, Robert Cooper, Shareholder in Labor and Employment in Buchalter's Los Angeles office.
Hello, everyone.
Just a quick disclaimer. Hi, Bob. Just a quick disclaimer. This is a timely and really important topic for employers. And it's important to note that the federal, state, and local guidance and orders regarding reopening and the measures that employers need to take are rapidly changing and evolving. So it's really important that you're routinely checking the various sources that we'll be flagging in this presentation, just to make sure that you're accessing the most up-to-date information. Today is Tuesday, June 16th, so this is especially important for you to keep in mind if you're watching a recording of this presentation at a later date. So our agenda for today will include a brief bit about state and local reopening orders and guidance, including state and local guidance broken down by industry, health and safety considerations in returning to the physical workplace. This includes important requirements from Cal OSHA, some considerations regarding creating a culture encouraging your sick employees to stay home, physical workplace issues, including, of course, physical distancing, disinfecting and cleaning policies, encouraging telework, what to do if an employee has or is suspected to have COVID-19 in your workplace, and how to communicate with and train your employees on health and safety. We'll also cover workers' compensation issues, FAQs for employers on COVID-19 symptoms, temperature screenings and testing, and workplace litigation mitigation considerations, which include considerations for avoiding wrongful termination, discrimination and retaliation issues, and we'll also go over some reasonable accommodation issues. And last, we'll briefly touch on some additional considerations, including remaining mindful of leave laws and wage and hour obligations. So where do we start? The first place to start is reviewing and understanding the orders and governmental guidance regarding reopening at the state, local, and even city levels. So in California, we're currently in stage 2 or lower risk workplaces of what's called the California Resilience Roadmap. So you can see that statewide, there's some retail and related logistics and manufacturing open, office workspaces, some limited personal services, outdoor museums, childcare, and essential businesses. And all of these sectors are open, subject to modification. Los Angeles County, however, for example, has been approved to move further ahead in the Resilience Roadmap. So here's a quick rundown of what's now open in LA County as of a June 12th health order. So parks are open, beaches and trails, public pools, gyms and fitness centers, golf courses, professional sports, however you can't have live audiences, music, film and TV production, and more. In terms of in-store shopping and services, grocery stores and pharmacies have been open, but now some additional lower risk retail stores can operate, and restaurants and cafes are open for some on-site dining now. In the healthcare sector, some additional clinics like dental clinics, the optometrist, mental or behavioral health clinics are now open. And of course, all the essential businesses that have been operating, as well as some office-based businesses, can now open, although telework is still really strongly encouraged. There is a Los Angeles County Public Health Resources page, which is linked here, and that includes a list of sectors that are approved to reopen in LA, more comprehensive than what we just went over. Los Angeles County specific reopening protocols, and the LA County Public Health Order, which has been periodically amended. And that includes some appendices with things like a social distancing protocol and some county protocols for specific industries. The webpage also includes some guidance for businesses like FAQs for managers, a notice that you can post for your customers regarding safety and health, guidance for cloth face coverings, cleanings, hand washing guidance. So if you're an employer with a workplace in LA County, it's important for you to be checking this website and the resources within it periodically for this important info. So San Diego County has also been approved to move further ahead in the state resilience roadmap and has been moving pretty quickly relative to some other counties. So here's a list of what's open now in San Diego. Things like card rooms, racetracks, places of worship with some caveats, car dealers, car washes, even tanning salons are open here in San Diego County. Again, restaurants with modified dine-in service. Outdoor recreation, you're allowed to exercise if you're 6 feet away from people that aren't in your household, though you still have to avoid large groups, and you have to wear cloth face coverings within 6 feet of others. So interestingly, coming soon, as of June 19th, it looks like San Diego County will allow certain personal care service businesses to open, including nail salons, facial salons, even tattoo parlors, and massage therapy in some non-healthcare settings. And I believe all these businesses are still closed in LA County. So I want to note that San Diego County has a dedicated COVID-19 resource webpage as well, which links to a specific safe reopening plan for businesses with a link that you can find at the bottom of this slide. So this reopening plan, it doesn't need to be submitted or approved by the county, but the template does state that businesses have to implement mandatory measures regarding signage and protecting employee health. The mandatory signage component includes posting signage at public entrances that advise all employees and customers that they should absolutely not come in to the facility if they have a cough, they have to wear facial coverings, they have to maintain 6-foot distance from one another, and not shake hands or engage in any unnecessary physical contact. And the mandatory measures to protect employee health require that teleworking opportunities have been maximized, all employees have been told not to come to work if sick, which really can't be overstated. And interestingly, the reopening plan also states that all employees have to have their temperature taken upon reporting to work. If a thermometer is not available, employees must be screened for symptoms. And that's a direct quote. So regarding temperature taking in San Diego, interestingly, the San Diego Public Health Order, as recently amended, now just states that employers should conduct temperature screenings, which would seem to sort of leave the door open for employees to screen themselves at home and then maybe self-report to their supervisors. So this is just one example of how there may sometimes be some tension in the guidance and the importance of keeping up to date with the information as it changes. And later in this presentation, we'll be addressing some specific considerations regarding temperature taking and how to assess whether temperature taking is right for your particular business, meaning whether it's feasible to conduct your screening safely, accurately, and with certain privacy considerations in mind. And just briefly, here's a list of what's still closed statewide. Indoor playgrounds, saunas and steam rooms, and then places where you would need large crowds to gather, including live theater, nightclubs, concert venues, festivals, theme parks, and higher education. So it's really important to check your particular county's COVID-19 webpage for any information regarding businesses that are permitted to reopen and any county-specific protocols that could possibly apply to you. And there's a link here at the bottom of this slide, as you can see. So now that we've discussed what's actually open and about to be open at the state level and in certain counties, and where to access some specific county resources and protocols, I want to flag that California employers also need to be aware of California's statewide guidance regarding reducing COVID-19 risk in the workplace. And we've provided links to this guidance right here in these slides. The California Department of Public Health, in connection with Cal-OSHA, which is the California Division of Occupational Safety and Health, has released statewide reopening guidance, which includes general guidance applicable to all employers, and then separately, some really important and helpful information for specific businesses and organizations that's broken down by specific industry. So first, as a general matter, per the state, all employers before reopening need to be doing the following things. Number one, employers need to perform a detailed risk assessment of their particular workplace and implement a protection plan particular to the workplace. So many businesses likely remain at lower risk regarding COVID-19 exposure, especially in the businesses that involve office work, which means that these jobs, they don't require contact with people who may be infected with the virus. They don't require close contact with the general public, and they require minimal contact with other coworkers. However, all employers really do need to be considering whether employees can be exposed to the virus or encounter someone infected with the virus in the course of their duties at work. Number two, employers need to train employees on how to limit the spread of COVID-19, which would include things like how to screen themselves for symptoms and advising folks to stay home if they have any of these symptoms. Number three, employers need to implement individual control measures and screenings, and we'll unpack what this means a little later in the presentation, and we'll also discuss some specific prevention and control measures and resources for additional information on infection prevention and control. Number four, employers need to implement disinfecting protocols, and we'll be providing some examples of what this means. Number five, employers need to implement physical distancing guidelines. And then second, the state has set forth specific guidance and checklists for tens and tens of specific industries, including retail, office workspaces, real estate transactions, life sciences, logistics and warehousing, childcare, delivery services, hotels and lodging, manufacturing, dine-in restaurants, salons, and more. Basically, each type of business and organization that's now allowed to reopen has corresponding industry guidance. And employers can also post the COVID-19 industry-specific checklists in the workplace after reviewing and following them. And as you can see, we provided links to the industry-specific guidance and the checklists at the bottom of this slide right here. In the same vein, we're going to be spending some time discussing the very many health and safety considerations that California employers need to be aware of in reopening. There's quite a bit of specific guidance on this topic that's out there, but the good news is that it's publicly available, a lot of it overlaps, and we'll be going over some of it here. And we've also provided links to lots of specific information about how to make your workplace healthy and safe during this time. So first, I want to just briefly address why we care so much about health and safety in the workplace. We all realize that it's critical to provide a healthy and safe workplace for obvious reasons, and it's unquestionably the right thing to do. But also it's important to keep in mind that employers actually have a legal obligation to provide and maintain a safe and healthful workplace. And Cal/OSHA can actually conduct workplace investigations if, for example, an employee were to complain, and they have the power to issue citations with financial penalties. Also, interestingly, the plaintiff's bar is getting pretty creative with their lawsuits. For example, there was a recently filed proposed class action by a group of McDonald's workers who have argued that McDonald's alleged failure to implement health and safety measures amounts to a public nuisance, which is obviously a novel application of this particular theory. So for these reasons and more, employers need to review health and safety guidance from the Federal Occupational Safety and Health Administration, Cal/OSHA, the Centers for Disease Control and Prevention, and really make sure that a written COVID-19 plan reflects this guidance. And again, we will provide links to the applicable guidance at the conclusion of this section of the presentation. So a quick word about injury and illness prevention programs. This is something that is specific to California. California employers are actually required to implement and maintain an effective injury and illness prevention program, or an IIPP, to protect employees from workplace hazards per both California's safety regulations and also the California Labor Code. The IIPP has to be in writing and accessible to all employees, and this was actually the case even before the COVID-19 outbreak. And I've read that the failure to have IIPPs is Cal/OSHA's most often cited violation. So that's a good reason to pay particular attention now and make sure that your company has a compliant IIPP. So per the pre-COVID-19 regulations, IIPPs have to include certain things. Responsibility. This means include the identity of the people with the authority and the responsibility in your organization for implementing the IIPP. And it's obviously even more important in these times to identify a health and safety task force at your particular workplace. Compliance means having a system for ensuring that employees comply with safe and healthy work practices. Communication, have a system for communicating with your employees about occupational safety and health matters. Have procedures for identifying and evaluating workplace hazards, including periodic inspections, procedures for investigating occupational injuries or illnesses, procedures for correcting unsafe or unhealthy conditions, work practices and procedures, and training and instruction for all your new employees, employees that take on new job assignments, and for all employees whenever the employer learns of a new or previously unrecognized hazard. Note also that most employers have to maintain documentation of steps that they've taken to implement and maintain the IIPP for 1 year. And this includes records of scheduled and periodic inspections and documentation of health and safety training. I want to note that if you don't have an IIPP, there are actually a bunch of online tools from Cal OSHA for creating IIPPs particular to your workplace, which are generated based on responses to certain questions that you can fill in online. And there's also links to model plans. Though of course, it's important to note that there's no substitute for reviewing and understanding the regulations and making sure that your plans are actually implemented. And also, the question is, do injury and illness prevention programs need to include any new information to address COVID-19 risk? And the answer is definitely yes. So this will require some thought and effort beyond just a generic plan that you could create or find online. So because of widespread community transmission, Cal OSHA has actually stated that it's now mandatory for most California employers to adopt changes to the IIPP to include certain infection control measures. So employers should also review CDC guidance to this end. Per the Cal OSHA guidance, the following infection prevention measures definitely need to be included in your written IIPP. Actively encourage your sick employees to stay home. Immediately send your employees home or to a medical office if they're experiencing any COVID-19 related symptoms. Ensure that employees that have COVID-19 symptoms don't return to work until at least 3 full days have passed with no fever, without the use of medication, and there are no acute respiratory illness symptoms. And also make sure that at least 10 days have passed since the symptoms first appeared. Also, you need to be providing employees with paid sick leave or expanded family and medical leave for reasons related to COVID-19, if that's required by the Family First Coronavirus Response Act or other leave laws or policies. Ensure that your employees that return to work following an illness that they may have had promptly report to you or a supervisor any recurrence of symptoms. Encourage your employees to telework from home whenever possible, and practice physical distancing by canceling in-person meetings. Use video or telephonic meetings instead. Maintain a distance of at least 6 feet between people at the workplace whenever possible. Provide employees with cloth face covers, or you can encourage them to use their own cloth face covers whenever they're going to be in the workplace with other people. Note that cloth face coverings are not considered personal protective equipment, but the recent data shows that combined with physical distancing of at least 6 feet, they may help prevent infected people without symptoms from unknowingly spreading COVID-19. Avoiding shared workspaces. This means avoiding the shared use of desks, offices, cubicles, also avoiding the shared use of work items like phones, computers, other work tools, and equipment whenever that's possible. If an item has to be shared workspaces and work items have to be cleaned and disinfected before and after use. Establishing procedures to routinely clean and disinfect commonly touched objects and surfaces. So this would include things like elevator buttons, handrails, copy machines, faucets, doorknobs, and these surfaces need to be cleaned with soap and water prior to disinfection. And disinfecting procedures also need to include specific things. For example, using disinfectants that are EPA approved for use against the specific virus that causes COVID-19, and a list should be available on the EPA website. Disinfecting procedures would also include providing EPA registered disposable wipes for employees to use so they can wipe down any common surfaces, and ensuring adequate supplies to support your cleaning and disinfection practices. Also, if you have an employee that's confirmed to have COVID-19 infection in the workplace, there must be a process for informing other employees of their possible exposure to COVID-19 while also maintaining confidentiality. So what does this mean? Employers need to take care not to identify anyone who's tested positive by their name in the workplace, although you can and should be notifying other potentially affected employees in a way that's not going to reveal their identity or their personal health information. So, for example, the California Department of Fair Employment and Housing recommends that an employer communicate with the potentially affected employee by stating something like, we've learned that employee at X office tested positive. The employee received their positive result on X date. This email is to notify you that you've potentially been exposed to COVID-19, and you should contact your local public health department for any guidance based on your particular circumstances. And you can actually find a specific blurb that you might want to use on the actual department website. Also, if it is the case that someone's confirmed to have COVID-19 in your workplace, you have to temporarily close the general area until the cleaning is completed, and you must conduct a deep cleaning of the entire general area, ideally via a professional cleaning service. Last, employers should also advise employees to avoid any non-essential travel if at all possible and be checking the CDC travelers' health notices prior to any travel. Per Cal OSHA, employers also need to be providing training on the following topics in a language that all employees can reasonably understand. This includes a general description of COVID-19 symptoms, which are found on the CDC website, when to seek medical attention, how to prevent spread, and the employer's procedures for preventing workplace spread, how an infected person can spread COVID-19 even if they're not sick, how to prevent the spread by using cloth face covers, and then seemingly obvious things like coughing and sneezing etiquette, proper hand washing, not touching your face with unwashed hands, avoiding shared personal items with your coworkers like dishes, cups, utensils, towels, even things like salt and pepper shakers, magazines in common areas, etc. Providing tissues and no-touch disposal trash cans and hand sanitizer for use by your employees, and safely using cleaners and disinfectants. Also, regardless of COVID-19 risk, all employers are actually already required to provide washing facilities that have an adequate supply of cleaning agents, water, and towels or blowers. And these regulations were in effect even before COVID-19. Also, per Cal OSHA, employers have to conduct a hazard assessment to determine if any personal protective equipment is needed to protect employees from workplace hazards. And those regulations were also in effect prior to the COVID-19 outbreak. Per the May 14th Cal OSHA guidance, the then current CDC guidelines don't recommend that the general public wear respirators or surgical masks to protect against COVID-19 in light of the shortages of respirators and surgical masks in the medical community. So Cal OSHA does not recommend that employees use respirators or surgical masks for most folks at this time, which is why they mention the use of cloth masks in their guidance. So as promised, here are some links to some resources regarding health and safety, Cal OSHA's full interim general guidelines on protecting workers, some additional industry-specific guidance, and federal OSHA guidance on preparing workplaces for COVID-19, which is helpful to provide some additional detail and ideas for infection prevention measures, things referred to as efficiency controls, like installing engineering controls, like installing high-efficiency air filters, ventilation, using plastic sneeze guards. And there's also some good information about how to categorize the level of risk in your particular workplace. And also CDC guidance for businesses and workplaces, and some helpful recent information for employers in office buildings that may have been mostly vacant during the beginning of the stay-at-home order, since there are some additional building considerations there. So these links are here. So we discussed employee training, but I want to underscore that while employers have to have a safety and prevention plan in place, employers also really need to show that it's actually effective, which means developing a communication plan and creating a culture focused on safety. And this can be accomplished in a variety of ways, and there are some suggestions here. You can have folks sign written acknowledgments of safety and prevention measures, increase signage in your workplace regarding sanitation and hygiene. In addition to the trainings that we talked about, have safety meetings, reminders regarding hygiene. You can even conduct audits to make sure that folks are actually physically distancing in the workplace and responding to employee safety concerns. So to recap, employers should be updating their current IIPPs to align with Cal OSHA guidance and any industry-specific guidance, also the CDC's guidance, implement general infection prevention and control measures, communicate with your workforce regarding the infection prevention and control measures, and create a safety-focused culture. Also, provide employee training on the related topics that we covered, and maintain documentation on safety and health protocols and on training provided to employees. So with that, I will turn it over to my colleague, Robert Cooper, to discuss an important SCOTUS update and more.
Well, thank you, Jessica. I'm Robert Cooper, as she said, a shareholder in our Los Angeles office. I've been an employment lawyer for 30 years. I've never seen, I don't think we've experienced such a volatile period in the law and in the workplace as employers are forced to go through right now. It's really been like the Wild West out there. And, you know, we've tried to stay ahead of both the safety issues for the sake of our clients and the regulations and guidelines that seem to come out almost daily. So I'm going to talk about a lot of things that have to do with litigation and keeping yourself as an employer safe from getting sued for things that might be related to the COVID virus, the COVID-19 virus, and people perhaps getting ill in the workplace and issues such as that. I want to go back, first of all, to what Jessica has been talking about, which is what is open and what is not. And we did have one Supreme Court case, United States Supreme Court case, that came out on May 29th that is interesting in that it dealt with an appeal by a church. Of course, the case came from California. Not surprising that the only Supreme Court case would come from there. In that case, which is called South Bay United Pentecostal Church versus Gavin Newsom, the church asked for an injunction of the limitations for opening up churches. And on the executive order that Newsom had issued limited attendance to 25% of building capacity and a max of 100 attendees at places of worship. But the church appealed that and asked for an injunction so that it could not have to go by those guidelines, because as the church argued, apparently in that case, this standard was not really similar to standards applied to other businesses, secular businesses, and I've kind of listed some of them there. At least that's what it argued. And so the argument was none of these businesses are subject to a 25% occupancy cap. You know, why are houses of worship? The Supreme Court had to consider this matter very quickly because it was an injunction. They were asking that the law no longer have to be followed. But the Supreme Court upheld the 25% occupancy cap for places of worship because it indicated that the First Amendment it did not feel was violated, because the Constitution leaves safety largely up to the states and not to unelected judges. You know, that decision, is typical of a decision that the Supreme Court might make because it really doesn't want to deal with an issue. It's easy to say, well, this is beyond our purview, but of course, in many other cases, they will go into things that you wonder why the court is dealing with. But in any event, all of this probably will pass, hopefully, for everyone shortly, and we won't have to worry about these issues quite as much in the near future. I want to talk next about workers' compensation issues. Every employer has a workers' comp policy, even if you have only one employee. And the real question that has come up is, now that businesses are returning to work, what is going to happen? Is workers' comp insurance going to cover people who may get sick? Or how is that going to work? And I think Governor Newsom did something really helpful to employers, which I'll go into in just a second. But first off, COVID-19 or illnesses such as, that come from viruses and things of that nature normally have not been covered by workers' compensation. And that's because workers' compensation is meant to relieve employers and employees of having to prove a negligence case where they get injured, but not necessarily for illnesses unless they can demonstrably be said to have been caused by something that happened in the workplace, like exposure to asbestos or beryllium or chemicals or things like that, that can more clearly be traced to the workplace. So normally, illnesses are covered by things like the FMLA, leave laws, the CFR, the CFRA in California, now paid medical leave, or if somebody gets a chronic disease, it's covered by disability and laws that relate to the disability laws. Part of the reason for that is it's very difficult to prove where someone got an illness unless it's a chemical exposure or something like that that occurred in the workplace. So traditionally, workers' comp probably would not have applied. But here, now we have the COVID-19 virus that apparently can be spread very easily. And so the question for employers was, what are we going to do? How is this going to work with respect to our workers' comp policy if someone in our workplace gets sick and spreads the virus to other employees? Is that going to be covered? Am I going to get sued for not having a safe enough workplace? What is my liability? And so the big question was, how is workers' comp going to interact with this? Now, the good news is a couple of things. Number one, workers' comp exclusive remedy provisions protect employers so that if someone does get sick and it's in the workplace, normally, if that can be proved, then your workers' comp policy would cover you. And that's a good thing because you don't want to get sued directly. Now, the other big part of the protection that you get with workers' comp is that it prevents people from suing, employees from suing their employer for injuries or illness that happen in the workplace, unless they can meet very narrow exceptions. If they don't meet one of the exceptions, then your workers' compensation policy and your insurance will cover you, and you don't have to worry about a civil lawsuit, which would be far more potentially draining and dangerous financially. What are those four exceptions? They're very narrow. The first one is assault. And I've never seen that in 30 years as an employment lawyer. An employer assaulting an employee, I'm sure it happens. But I guess the reason they put that in there was to make sure that that's not limited to a workers' comp case if that actually happened in the workplace. The second exception is called the fraudulent concealment exception. That one is also very hard to establish. And what you have to prove there is that you had an illness that you weren't aware of, but your employer was aware of it, and something that your employer allowed to happen in the workplace actually aggravated your injury. So you can see it's a very narrow fact scenario that would lead to getting around your workers' comp policy and allowing an employee to sue you directly. The third one is also narrow. It's called the dual capacity doctrine. That's where your employer sells a product that you buy out in the marketplace and that product injures you. In that case, you're considered just like any other consumer, and you could bring a lawsuit directly against your employer because their product injured you. And in that situation, you're considered to have a dual capacity. You're not just an employee, you're also a consumer. The fourth exception is called the punch press exception, and that's where in a manufacturing environment, there's a machine that has a guard on it to protect a worker from getting injured by the machine. And if the employer takes the guard off or doesn't have it, then you can sue your employer directly as though it's not a workers' comp situation, makes it a civil situation. So it's very difficult to sue to get around the workers' comp bar. But Governor Newsom, I think, did something very helpful to employers when he passed an executive order regarding workers' compensation. And that executive order shifts the burden in workers' comp cases. What does that mean? That means that normally the employee has to prove that he got whatever illness or injury he's claiming. He's got to prove that it, or she has to prove it happened in the workplace and it's caused in the workplace. Governor Newsom's executive order shifts the burden to the employer to prove that with respect to COVID-19 and a positive contraction of the virus, that the employer now has to prove that it didn't happen in the workplace. So the effect of that will be positive for employers because it's going to mean that if one of your employees contracts COVID-19 in the workplace or within 14 days of having worked, it's going to be presumed to be covered by your workers' compensation policy. And I think, you know, the only downside of that is, of course, that perhaps an employee who really didn't get exposed to the virus in your workplace is still going to have access to your policy. That could make your workers' comp policy premiums go up, but that's really much lesser of a worry than getting sued directly by an employee for some kind of safety action that you should have taken that you didn't. So it's really going to protect employers from third-party suits, even though they would be hard to bring against your employer to begin with. So let's talk about some what we call frequently asked questions, or FAQs. What's interesting about FAQs is that as we've been trying to keep up on the law and the regulations that are relating to the COVID-19 virus, the laws passed for various benefits that the federal government has passed are changing so quickly that almost on a daily basis, the federal government has been issuing FAQs. They are almost having the force of law, which is something I've never seen as a lawyer. We get a new clarification every day, and that acts to guide us as lawyers as to what the law is. It's so fast and furious that it's very unusual, and of course, very difficult for employers to keep up on. But so these FAQs relate to what employers' responsibilities are in the workplace in terms of the privacy and disability laws. First one, can an employer ask questions, ask employees if they're experiencing COVID-19 related symptoms? The answer is, of course, yes. And one thing to keep in mind about the FAQs I'm going to go through right now is that normally none of the things employers are not only allowed to do, but required to do with the COVID-19 virus are normally legal or allowable in the workplace because of our privacy laws. So medical screening and things of that nature are normally very strictly regulated in the workplace. But now, under these unusual circumstances, we have a lot of new guidelines from the federal agencies and the federal government. So yes, you can, of course, ask an employee who's come back to work whether they have symptoms. The next one, can an employer send an employee home if he or she is displaying COVID-19 symptoms? The answer to that is yes. Obviously, everyone wants that to be the case because we have to eliminate all exposure. And as Jessica was saying, and it's in fact the employer's responsibility to ensure that the workplace is safe under OSHA guidelines. In terms of symptoms and screening, can an employer require an employee to stay home if he or she has symptoms? Yes. Again, that's what we want to do to isolate those who are sick. And normally, that's something that would be delving into privacy of the employee to even know what their symptoms are or if they have an illness of any kind. The HIPAA laws and other laws would normally prevent employers from inquiring or sending an employee home. But under these circumstances, it's clear that under the EEOC and the California Department of Fair Employment and Housing guidelines, employers can do that and need to do that.
Yeah, another quick caveat to this, Bob, is that while you can certainly ask employees about COVID-19 related symptoms, it's important to keep these questions cabined to the symptoms as defined by the CDC, like fever, chills, cough. The list is evolving, but employers should stay up to date with how the CDC defines the symptoms, and be really careful to just keep your inquiry limited to these particular symptoms, so you're not inadvertently kind of delving into sensitive medical or disability related information that you shouldn't be privy to. And of course, employers always have to maintain all information about employee illness as a confidential medical record kept separately from their personnel records. So just a quick caveat to that.
Right. And going into my own tennis club now, I have my temperature taken every time I go there, and they ask us a series of questions about our symptoms. And it seems like that is what really every employer that reopens is going to be doing for the near future until all of these guidelines are relaxed. And again, if an employee is sent home with symptoms, then employers have to think about the paid leave laws and compensating employees. In the past, of course, the Family Medical Leave Act wasn't a paid leave act, but under the new federal PPP and CARES Act, employers can be responsible for as much as anywhere between 2 to 12 weeks of paid leave. So that is a very potentially onerous financial burden that employers have to keep in mind that they may have after reopening. Next, during the pandemic, can the employer ask employees to self-report symptoms? Yes, and that's usually part of any employer's set of guidelines in their plan, as Jessica was mentioning. It's up to employees to communicate with employers to make sure they and their fellow employees are kept safe, and that those who potentially have contracted the virus can be isolated and sent home so that the entire workplace isn't threatened. Now, in terms of temperature screening, we talked about that a little bit previously. This is an example of something that would never fly, wouldn't be allowed due to the privacy laws. You can't ask to take an employee's temperature under normal EEOC guidelines, because that's a medical examination that requires all kinds of different qualifications in order for an employer to be allowed to do it. Excuse me. But now, of course, it is permitted during the pandemic. And at first, we believed that we should probably get authorizations to do these kind of examinations, but and so most employers are doing that, and that's a safe way to proceed. But it's definitely something that employers can do and need to do when reopening now under the current situation. Yeah, now the next one is temperature screenings and COVID-19 testing. During a pandemic, can an employer require that employees to take a test before permitting them to enter the workplace? The answer is yes. Of course, that would be a clear no prior to the pandemic. And the important thing to keep in mind is that per the EEOC, they can do it, but the ADA, the Americans with Disability Act, requires that any mandatory medical test of employees be job-related and consistent with business necessity. So, applying this standard, employers can take steps to determine if employees entering the workplace have COVID-19, because an individual with the virus will pose a direct threat to the health of others. But note that the EEOC has stated that employers need to make sure that any testing is accurate and reliable. Employers can review FDA guidance as to safe and accurate testing and any guidance from the CDC or public health authorities. Also, keep in mind that any decision to screen or test should be based on objective facts and implemented on a non-discriminatory basis. In other words, there shouldn't be some kind of random decision about who to test and who not. There should be a set of facts that leads to some objective reason to have that person get a test. Obviously, the main one would be that they have symptoms or they've been around someone who had contracted the disease or some similar set of facts. Of course, any screening or testing still has to be done in the most private and least intrusive manner possible. You don't want all the employees in a line together being tested and seeing each other, potentially be sent home, and you don't want to be violating their privacy to the largest extent possible. You want to be protecting it. So employers especially need to be aware of the need for confidentiality of medical data and test results, and certain privacy issues associated with collecting medical data. For example, the potential need for notices to employees regarding the type of information being collected and the purpose of collection, protection against unauthorized use or disclosure. Pardon me, employers should compensate non-exempt employees for time spent submitting to safety protocols, including sanitation procedures, screenings, and testings, because this could constitute off-the-clock work. We have a recent case involving Starbucks that really clarified the law that really there's no time that an employee spends in the workplace or getting ready to start work that should be uncompensated. And there was something in the past before the Starbucks case called de minimis time that's virtually been eliminated. So all time that employees are at the workplace, whether they're screening, getting ready, or washing their hands, all of those things, they're still on the clock essentially and should be compensated.
Yeah, that's right, Bob. And actually, there's a recent class of workers who filed a proposed class action under federal law, the Fair Labor Standards Act, and certain state wage laws in federal court in Illinois, alleging that they weren't properly compensated for time spent related to the increased safety protocols related to COVID-19. So we're actually seeing this off-the-clock work issue litigated, and I think it's expected to be heavily litigated. Outcomes will probably vary based on each state's wage and hour laws. But, here in California, usually we're erring on the side of compensating folks. Just earlier this year, the California Supreme Court held that employees who spent time in anti-theft security screenings at Apple stores was compensable because the workers were under the company's control. So the best practice here in California would be to be compensating non-exempt folks for extra time that they may have to spend submitting to screenings or cleaning and the like.
Right. No millisecond of time goes uncompensated in California now. That's where we've been going, and that's pretty much where we are. So it's always important for employers to keep that in mind. So some of these things in the next slide to keep in mind are things we've been talking about, which are decisions to test or screen must be based on objective facts, not implemented on a non-discriminatory basis. In employment law, employers can do things that are neutral and not intended to be discriminatory, but if they have a discriminatory effect, such as against one race or one gender or one ethnic background, an employee can actually bring a discrimination case even if the employer did not intend to purposefully discriminate, as long as their policy somehow ended up doing that. That's something to keep in mind. And that's why all testing and decisions about who to screen and how to screen them should all be even-handed and done across the board the same way for all employees. And we talked about this. Testing must be done in the most private and least intrusive manner possible. It's got to be accurate and reliable. And employers will also need to be aware of confidentiality and privacy issues. If any employee tests positive for the virus, that fact should be kept confidential. And the employee who does test positive needs to be told that it will be kept confidential and that their privacy will be protected. That being said, as Jessica was talking about earlier, employers also have a duty, once an employee has contracted the virus in the workplace, to figure out and communicate with that employee and others to determine to whom they were exposed, who were they around, what areas of the work site were they working at, so that that can be completely disinfected. And in that process, it is going to be a tightrope for employers to, keep the identity of the employee confidential, especially in a small workplace. But employers just have to do the best they can to protect the privacy of employees on that score. We also talked about compensating non-exempt employees for additional time spent submitting to safety protocols, which could be thought of as off-the-clock work. So there's great reference materials for all the things we're talking about, and those are things that employers really should rely on and make reference to whenever they have questions, as well as calling their lawyers and they're talking to their HR folks who are knowledgeable. So the EEOC technical guidance for employers is one link that we've added here. Also the DFEH employment information for COVID-19. Those links cover, how to conduct yourself as an employer without falling into some kind of conduct that could be considered discriminatory. So let's talk about litigation and wrongful termination, retaliation issues. What is going to happen is an unknown at this point because we're still in the pandemic. But when the smoke clears and employees go back to work, we're likely to see a lot of claims, some of which Jessica was already alluding to. We might see discrimination claims as employers decide, who they're going to bring back to the physical workplace and when. So, for example, when an employer has to reduce its workforce, there are guidelines that govern how that has to be done. And the main thing is employers have to have neutral factors in terms of neutral criteria in terms of deciding who is going to be hired and who is not going to be hired, who's going to be laid off. So the considerations are listed here. Determine which positions or functions are needed most immediately. Use neutral criteria based on business necessity. Obviously, you can't use protected categories such as race, ethnic background, gender, and those things that are covered in the discrimination laws. You have to create a consistent, non-discriminatory selection policy. Pardon me, and that is something that I've counseled employers over many years to actually create a flow chart in a situation of bringing people back or letting them go, so that if one employee does bring a discrimination claim, you can present in a very organized and articulate way the thought process of the employer in how they let people go and how and why they brought them back. And so consider statistical analysis. That kind of dovetails with that. It may be that you created a flow chart which included seniority, had a performance aspect to it, and had dealt with each different department and how many employees they need. And so all of those factors that you used, it's a good thing to create a chart, something in writing in your system that you can refer to in case you ever face a discrimination claim. All right, so with respect to wrongful termination, discrimination, and retaliation issues, terminated employees may bring suit under the federal and state anti-discrimination laws, challenging the reasons they were subject to an adverse employment action. Of course, these laws are on the books, not just during the COVID-19 pandemic, but at all times. But again, the mitigation considerations should always consider these laws and how you could even accidentally fall into some kind of criteria for bringing people back or laying them off that creates a pattern that suggests discrimination. So again, it states the best policy: use objective criteria in making layoff determinations, assess whether there may be disparate impact, even if it wasn't intentional, resulting from neutral criteria, and always keep some kind of flow chart and document how you are doing things as an employer so that you can protect yourself later from discrimination claims. Now, all of these things, with all of this volatility, with employers having laid off so many employees, and now with employees coming back and some employees not coming back, we can expect there's going to be some employees who say, hey, how come I didn't get to come back to work and my fellow employee did? And so I think we can expect that there's going to be a lot of litigation that relates to discrimination claims for race, national origin, disability, and things like that, if employees feel that employers were discriminating against them in the decisions made about their jobs.
Right. And employers should also really be communicating to employees that any fear that they might have related to the COVID-19 pandemic should absolutely not be misdirected towards certain individuals because of a protected characteristic. And the EEOC recently made clear that managers should really be on high alert for any sort of hostile remarks directed to employees who are or perceived to be Chinese or of other Asian national origin. And people might have, fear that they have a colleague who has COVID-19, and we want to make sure that there's no harassment or hostility directed to anybody because of a potentially protected category. So it's really important to make sure that your anti-harassment and discrimination policies regarding prevention and reporting and investigations are up to date. And it might be a good time to remind your employees that harassing or discriminating against coworkers due to a protected characteristic is illegal. The EEOC also recently mentioned that given the new remote work environment, employers should really be making clear that if you're harassing someone via email or call or Zoom, that's also prohibited, and it's going to be treated the same way as it would be in person. And to that end, employers can also consider additional compliance training and remind managerial employees of their roles in watching for and stopping and reporting any sort of harassment or discrimination that could be related to COVID-19.
Right, and it's going to be interesting to see what happens when California employees return to the workforce en masse. I think we can expect that some of these claims are going to shake out, and so employers need to be aware, need to document, need to be conscious of the discrimination laws. Another issue that we've already talked somewhat about is health and safety concerns that employees may raise, or whistleblower retaliation claims. These could relate to safety problems in your workplace that cause employees to perhaps contract the COVID-19 virus. The important thing to note is that these mitigation considerations are going to save you from having to deal with these problems. You can't stop employees from suing you, but you can have your mitigation and your policies in such a place that no case against you is going to be viable. So, make sure you're complying with all the safety laws. All of the information is readily available. The OSHA, Cal OSHA, CDC guidance, all of that information is there. A lot of it we've linked to here. You need to create a safety-focused culture when you return and reopen your workplace. Consider updating your anti-retaliation policies to cover complaints related to COVID-19. Consider training of supervisors. Maintain a channel for reporting health concerns. Closely vet any decision regarding potential adverse employment action against an individual who's complained about health and safety, because that is where you can get a retaliation whistleblower case, and that's going to be potentially brought by a person that isn't necessarily sick from the virus, but has complained about safety, and it's just as bad as any other lawsuit that you're going to face from your employees. Next, let's consider reasonable accommodation issues. Now, what do you do if an employee does have an illness related to COVID-19? Does it rise to the level of a disability? That's going to remain to be seen. I think it's going to be pretty obvious for those unfortunate employees who may get very sick. Clearly, they're going to be disabled at that point. I think that it's going to look less like disability because COVID-19 illnesses tend to be either serious or on the other extreme without symptoms or very minor symptoms. And so that may not rise to the level of a disability. But obviously, if someone is sick and they've tested positive, but they're still able to function, you may need to reasonably accommodate them. How do you do that? Well, of course, the obvious one is working remotely if they can. That's usually something that is not a hardship for employers. There are obviously some jobs, such as being on a factory floor, where you can't accommodate them by having them work remotely. They need to be there at the work site. But what employers need to think about is there anything I can do to accommodate this employee so that they can continue working even though they may be debilitated by having contracted the virus? It's hard to know how widespread that problem is going to be, but just remember that the standard is, if you can accommodate the employee in a way that's not an undue hardship for the employer, then you are required by law to do so. So that's what you're going to need to consider when employees contract the virus, if that happens.
Right. And the EEOC is also provides some examples of some recommended quote unquote low cost accommodations that can be made on a temporary basis, whether that's one-way aisles in the workplace, putting up a plexiglass barrier, temporarily transferring folks to a different position, modifying work schedules or shift assignments. Those are some examples that the EEOC has specifically provided if a job can only be performed on site. And interestingly, regarding undue hardship in the time of COVID, you can ask yourself, what makes sense for your business given how it's structured? And per the DFEH, factors for determining undue hardship can include how many employees you have, the size of your budget, the nature of your business. And interestingly, the EEOC has also recently said that an accommodation that wouldn't have posed an undue hardship in normal times could pose one now. And if you're an employer who's had a sudden loss of some or all of your income stream because of the pandemic, that can actually be a relevant consideration for what would be an undue hardship. So I guess that's the EEOC throwing a bone to the employer in that situation.
It happens very rarely.
Right.
Consider reasonable accommodation issues. Generally, employers may request reasonable documentation confirming the existence of a disability and the need for reasonable accommodation, but you have to keep in mind that it's not always going to be possible for employees to obtain that, given the way doctors can be overloaded with this stuff. They're not open right now, largely, and so the DFEH has recommended that employers waive the requirements of actually providing medical certification. That's a decision that employers are going to have to make for themselves. It's normally a good idea and something I'd recommend to get medical certification or to require an employee to do so when they're in a situation where they may have contracted this virus. Higher risk individuals. Can an employer exclude an employee from the workplace because the employee is considered, quote, higher risk for severe illness if they contract COVID-19? For example, if they're 65 or pregnant or have a pre-existing medical condition. The answer is no, per EEOC guidance. You can't treat vulnerable employees any differently from their peers, even if the employer means well in doing so and is simply trying to protect the workplace. You can't do that because that is considered discrimination. Under the ADA, that kind of action is not allowed unless the condition poses a direct threat to the employee's health that cannot be eliminated by a reasonable accommodation. Whether the condition poses a direct threat to the employee's health is a high legal standard, and it has to involve an individualized assessment based on a reasonable medical judgment about the employee's disability. Not disability in general, but using the most objective evidence that you can. The ADA regulation requires a multi-factor analysis, even if an employer determines that an employee's disability poses a direct threat to the employee's own health. The employer still cannot exclude the employee from the workplace unless there is no way to provide a reasonable accommodation or unless there's an undue hardship. So also under the Age Discrimination in Employment Act, a covered employer is barred from involuntarily excluding an individual from the workplace based on the fact that he or she is above 65, even if this is for benevolent reasons again, such as protecting those at high risk for COVID-19. The ADEA, the Age Discrimination Act, does not include a right to a reasonable accommodation for age, but employers are free to provide flexibility to workers over 65, even if this means younger workers will be treated less favorably because that act doesn't protect workers under age 40. Under Title VII in the Civil Rights Act, an employer may not exclude a pregnant employee from the workplace involuntarily, even if motivated by a benevolent concern, because this could constitute sex discrimination. Pardon me, Title VII includes discrimination that's based on pregnancy. So also note that California's statewide guidance indicates that higher risk individuals, such as those over 65 or with a serious medical condition, should stay home until stage 4, which is the end of the stay home order. The Los Angeles County Health Order also states that those 65 or older or those with pre-existing health conditions should stay home as much as possible, and that telework is strongly encouraged. I think one thing that's going to come out of this is that telework is going to be far more prevalent because I think employers have discovered that it's possible and it's efficient in many cases. So I think that's going to be a change that we can expect. And so that is an accommodation that will often now be expected, whereas in the past, maybe it wouldn't be. There is some tension between the federal and state and local guidance, but the best policy is always to comply with federal law on these discrimination issues, because that certainly will be in place. The bottom line is don't make blanket assumptions or policies regarding individuals that may be at higher risk for a COVID-19 infection. Don't bar those employees from returning to work, and conversely, don't force those employees to return to the workplace. Evaluate each one on a case-by-case basis. Now, family members, the question is an employee entitled to an accommodation under the ADA in order to avoid exposing a family member who is at higher risk of severe illness from COVID-19 due to an underlying medical condition? Again, the answer is no. The ADA does not require that an employer accommodate an employee without a disability in order to protect a family member with a disability from potential COVID-19 exposure. For example, an employee without a disability is not entitled under the ADA to telework to protect a family member. And we've given you a link to some guidelines from the EEOC on that question. What about employees who are simply afraid to return to work because of the COVID-19 virus and the fear that they might contract it? That issue, the general answer is that's not enough. Just generalized fear of returning to work because of the virus is not enough for an employee to be considered protected by the ADA or other laws. the fear has to be connected to actually specific facts, such as uh, the fact that the workplace actually is violating OSHA guidelines or is for some reason unsafe, or various individuals had contracted the disease. I think it's a, I think it's a question which employers should move cautiously about. You don't want to have a blanket reaction, but at the same time, fear alone that's generalized of just returning to the workplace is not going to protect that employee um, from violating your attendance laws. Jessica, did you have a comment on that?
Yeah, so that's exactly right. Generally speaking, an employee simply can't refuse to return to work, and a generalized concern alone isn't considered a disability under the ADA. But there are some other considerations at play. Employees could have rights to paid time off under federal, state, or local laws. And in certain narrow circumstances, a refusal to return to work can be considered protected conduct under OSHA regulations. So if an employee can actually refuse to return to work if they really reasonably believe that they're in imminent danger of death or serious injury, and that they've notified the employer, and that there's not enough time to eliminate the danger. But, again, this can't be a generalized fear and has to be a real and identifiable condition. So if you're an employer who's following CDC and OSHA guidance, it'll be difficult for your employee to show that they're in actual imminent danger. But I think it's important to be mindful that there are some protections for employees who are afraid under the OSHA regulations. Also under the National Labor Relations Act, that act actually gives workers, whether or not they're unionized, a job-protected right to engage in concerted activity for the purpose of protection, which could conceivably include protesting unsafe working conditions. But again, this protects group-based activity, not because you're afraid to work solely to protect yourself. And again, you would have to have a pretty good faith concern that working conditions are unsafe. And of course, we've talked about the ADA. The law requires that disabled employees are provided with reasonable accommodations to do their job. So an employer may have to let an employee with a condition that puts them at higher risk for COVID complications. The employer may have to allow that particular employee to work remotely, even if their office is reopened. But again, note the caveats above. You can't make sort of blanket assumptions about folks in high-risk groups. So what can an employer who's particularly worried about vulnerable employees, what can that employer do? The best thing to do is empower your employees to self-identify and request accommodations if they believe that that's necessary. Some employers have considered polling employees to gauge whether the employer would like an accommodation based on a medical condition or another COVID-19 related situation. And then just communicate with your workforce. Explain to the concerned employee all of the health and safety measures that you're taking, because just as a practical matter, employees who are informed and feel comfortable and feel assured are far less likely to be having issues in returning to work.
Yeah, and so obviously another consideration that we've touched on is the leave laws, and these were complicated by a whole brand new set of leave laws that the federal government passed in response to the COVID-19 virus. Obviously, there are now paid sick leave laws, and previously the FMLA and the CFRA, those were unpaid family leave laws, and so employers didn't have to think about necessarily the financial impact of those laws. But now you've got to think about not only the FMLA and the CFRA, the pregnancy disability laws, PTO and vacation time, but now you've also got to think about the Federal Families First Coronavirus Response Act, and that applies to employers with fewer than 500 employees. That means it applies to most of the businesses in the United States because the vast majority are under 500 employees. There are also sector-specific emergency paid leave laws. For example, the California supplemental paid leave for food sector employees if they have 500 or fewer employees. And of course, as I mentioned, the unpaid protected leave laws were already on the books before the COVID-19 pandemic, include the FMLA and CFRA leave, the ADA and FEHA disability accommodation law, and workers' compensation leave. Of course, the leave laws by themselves are a whole webinar because they're complicated, but other than the new Families First law, employers hopefully have been dealing with those laws for a long time. It's very important to that the Families First law, Families First Coronavirus Response Act does include anywhere from 2 to 12 weeks of paid leave for a variety of reasons, including contracting, of course, the coronavirus. So be very conscious as an employer of what the leave laws are. Can your employee use PTO or vacation time for some of the time? Do you have to pay them? How long do you have to pay them? And all of those things. It's always a good area to consult your legal counsel on that score. Lastly, let's think about wage and hour issues. Of course, those issues never go away, but you've got to be conscious of the fact that during the pandemic, employers may have laid off some non-exempt employees and transitioned their duties to others or cut salaries. So employers should be conscious of classification issues. Employers should conduct an audit to ensure that employees are properly classified, meaning that exempt workers must be performing exempt duties and salary thresholds must be met. To be exempt in California, I believe right now, it requires a salary basis of pay of at least $50,000 to $51,000, depending on how many employees you have. Also, off the clock work, as we mentioned before, California's non-exempt employees should be paid for time spent adhering to additional sanitation and safety protocols. I know we're going to see cases about that, as Jessica's already mentioned. And also remember your ongoing wage and hour obligations. You have to pay wages in a timely manner. You have to pay final wages on the date of separation or within 72 hours if an employee quits. You have to furnish compliant wage statements and make sure you provide business expense reimbursements. There may be additional expenses incurred from transitioning to a remote work environment, and under the California Labor Code, any such expenses would have to be reimbursed to the employee. Well, thank you. I think we've covered everything. So thank you, everyone, and thank you, Jessica.
Thanks, Bob, and thanks everyone for joining us.